Welcome to the second half of the presentation on Chapter 13. This chapter deals with substantive criminal law as well as criminal procedures. In the first presentation, we focused on the substantive aspects of criminal law, and in the second half, which is actually probably more like the last third of the lecture, we're going to talk about the criminal procedures. So I'm going to fast forward from slide 1 to slide 18. Here we go. Actually, one more slide. So here we're going to start on the procedural side of things, and from here on out, we'll primarily be discussing procedure. So how does the criminal procedure system works? Much of this is going to be familiar to you if you've ever watched an episode of Law and Order or any other show that involves police officers and or district attorneys. Obviously, the first exposure that a criminal defendant has to the system is going to be at the time of his or her arrest. And of course, being arrested means to be taken into custody, to lose one's freedom for at least some period of time. And part of that process of the arrest is being booked. And so the first part, arrest, it fits into this definition, to take into custody. And the booking part is to enter the name and offense into a police log. That's that booking process. In order for a person to be lawfully arrested, there needs to be probable cause for an arrest, and there has to be probable cause in order to get that arrest warrant. And there are two requirements to find probable cause. First, there has to be likelihood that a crime has occurred. Second, there must be likelihood that the person who is being arrested actually committed the crime. Those are two elements. It is not a very high standard. It doesn't have to be a preponderance of the evidence or clear and convincing evidence or beyond a reasonable doubt. It just has to be a likelihood that a crime has occurred and that the person you're arresting committed the crime. The fact that someone is arrested doesn't mean the investigation is over. The police probably will continue investigating the matter, and they might find that they've arrested the wrong person, and then of course they will release that person and perhaps arrest another person. So a probable cause is not a huge hurdle to be crossed. Sometimes the police don't need an arrest warrant to arrest somebody, but the ordinary order of things is that an arrest warrant is obtained before the arrest occurs, and the method that the police use to get that arrest warrant is they go to a magistrate, which is a judge, and present, typically by affidavit, the evidence that they have to satisfy these two conditions. And once they satisfy them, the magistrate will issue an arrest warrant, and then the police officer can execute the warrant, in other words, arresting the person. In addition to needing probable cause in order to arrest somebody, you also need probable cause for that search warrant. You may recall, let me just flip back here, when we were on the Fourth Amendment. Fourth Amendment prohibits unreasonable searches and seizures, and that you have to have a probable cause for both a search warrant and an arrest warrant. And it's the same standard, really, to get probable cause for the search warrant as it is for an arrest warrant. This is the process. I really like this slide. It's an important example of how the criminal justice system works. And so let's kind of spend some time on this. Okay, the first step is that arrest, and you can hear it with there's a little summary about what happens. Police officer takes suspect into custody. Most arrests are made without a warrant, meaning, as I said before, there's an exception. You don't have to have a warrant in every case. If the police officer, for example, actually sees the crime being committed, or there's exigent circumstances, for example, if they don't arrest the person right now, it may be hard to find this person later, then it's not necessary for the police officer to get a warrant. But in the ordinary process, the institutional process, the police officer should get an arrest warrant if those two categories aren't satisfied. As I said before, it's not unusual for those exceptions to actually be pretty common situations. After the arrest, the officer searches the suspect, who is then taken to the police station. Now, this search does not require a search warrant as it would ordinarily. The purpose of this search is really for the safety of the suspect and for the officer. If the officer were to arrest the suspect, and the suspect, say, had a gun in his possession or some other weapon, the suspect might use it on the officer or some member of the public after the arrest has occurred. And so that's the focus, not so much to obtain evidence against the suspect, but to keep the suspect, the general public, and the officer safe. So after the suspect is arrested, then he or she will be transported to the police station for booking. At the police station, the suspect is searched again, photographed, fingerprinted, and allowed at least one telephone call. After the booking, which again is that recording of the information, charges are reviewed, and if they are not dropped, a complaint is filed and a magistrate reviews the case for probable cause. So if an arrest warrant wasn't procured beforehand, this is the check on the system. If it ends up that there's just not enough evidence for probable cause and the magistrate refuses to find probable cause, then the suspect will be released. And that doesn't mean that he's innocent of the crime. He may be, probable cause may subsequently be found. So after he has been booked, and of course that's going to be the usual process here, then there's going to be that initial appearance. And here when we say appearance, we mean the initial appearance before the court, before the judge. So this is the kind of the first opportunity that the arrested person has to kind of speak. So the suspect appears before the magistrate, again, just a judge, who informs the suspect of the charges and his or her rights. Again, the suspect should have already been Mirandized at the time of the arrest, perhaps even before the arrest. But also, this is a more detailed explanation about the rights. If the suspect requires a lawyer, one is going to be appointed at that time. The magistrate sets bail. Of course, bail are the conditions under which a suspect may obtain release pending the disposition of the case. So that's what happens at the initial appearance. Now we have some bifurcation here. There's two paths that a case can follow at this point. If it's going to be a felony, we're going to go over here to the grand jury and indictment portion. If it's a misdemeanor, we're going to go to this preliminary hearing information process. We happen to have the same process in Texas as we have in the federal system. Some states are going to have fewer times where they go to the grand jury. Here's a little reminder, it's a Texas-specific requirement. You're not going to find this in the textbook, so I draw your attention to this because this is information that can be covered in a test. In Texas, all felony charges require grand jury indictments. Now, you may have a few questions about that. One question might be, well, when we were looking at the Bill of Rights, let me flip back here. I think it's in the Sixth Amendment. It might be the Fifth Amendment. Let me go ahead and flip over. Oh, wait a second, I pulled up the wrong document. I apologize. I might have already minimized it. Let's see. Okay. Take me just a second to find it, and then we'll go forward. Okay, it is the Fifth Amendment. So let me just put that up here so you can see it. So here's the Fifth Amendment. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. So you may think, well, why does a state get to opt out of this? It seems pretty clear. A capital or other infamous crime sounds like a felony to me. Why do some states not require an indictment? It looks like it's unconstitutional. Well, keep in mind that these protections, when they were initially created, just protected citizens from the actions of the federal government. They had nothing really to do with the relationship that citizens had with each other or the citizens had with their state government. The idea is that the protections that the citizen would have vis-a-vis his or her state would be in the state constitution, not in the federal constitution. And of course, most states had protections, or many states had protections like this for the citizens within their own state constitution. It wasn't until we got to the 14th Amendment, let me put that up here for a second, that we had, this is many times called the mini Bill of Rights, and this talks about due process of law with respect to state action. Here we have it. Nor shall any state deprive any person of life, liberty, or property without due process of law. And so this protection is interpreted by the Supreme Court to mean that many of the protections found in that Bill of Rights, the first 10 amendments that used to only apply to federal action, now through the 14th Amendment, now also apply to state, meaning the state of Texas or the state of Mississippi or the state of Massachusetts or whatever, that state also has to follow some of the protections, but not all of the protections in the Bill of Rights. And one of the protections that has not been found to apply to states is that requirement for a grand jury indictment. Now you may be thinking, well, okay, maybe it's not a constitutional issue for states, but it sure sounds like a good idea. Why would a state not want to have it? Well, there's a few reasons. One is that although on paper it sounds like it's a good protection for citizens to have that kind of independent group of citizens who review the case before it goes to trial, so that if the district attorney is really not treating the defendant well or fairly, that the grand jury can kind of address the problem. As a practical matter, though, that's not really how it typically works. The grand jury only hears from the prosecutor. And the grand jury, the prosecutor is the only person who gets to present evidence. And the prosecutor and the grand jury typically develop a pretty close relationship. Typically, a grand jury is called not just for one case, although sometimes that happens, but it's called for a period of time. And so the grand jury develops kind of a rapport with the district attorney. And so there's a saying, in fact, that a grand jury would indict a grilled cheese sandwich if the DA wanted it to. So it doesn't really function as much of a check on the power of the district attorney. You may think to yourself, though, but Groover, I've heard times where district attorneys have no-billed somebody. When you say no-bill, you're saying they did not indict somebody. In most of those cases, that happened because the district attorney didn't take a position on it. The district attorney might have presented the facts to the grand jury, but the district attorney didn't say, and I want you to indict. And it kind of gave the grand jury flexibility. That's not a common thing to happen. Most of the time the district attorney is going to take a strong position. But sometimes the district attorney does take a neutral position, perhaps because it's a controversial issue in the community. Maybe the district attorney wants to be able to say when he runs for election next political cycle, that he attempted to get an indictment, presented the facts to the grand jury, but the grand jury decided not to seek to grant the indictment. And so it gives the district attorney some political cover, so to speak. And I don't mean that in a bad way. I just mean that he is in some sense saying, hey, grand jury, you make this decision for me. There's some passing of the buck. And I don't mean that in a negative way, but just kind of the way the process works. So if you see a grand jury not return an indictment, many times it's because of that reason. So let's look at the grand jury path for a second. We have the grand jury. Grand jury determines if there is probable cause to believe that the defendant committed the crime. We have this term probable cause again. We saw it appear with the arrest warrant. We also saw it with the search warrant, and now we're seeing it the third time with the grand jury. So this is a much lower standard that the grand jury is looking at than what a petit jury or a trial jury is going to be looking at. So the grand jury is just trying to determine if there's probable cause to believe that the defendant committed the crime. The federal government, again because of that Sixth Amendment, and about half of the states require grand jury indictments for at least some felonies. And again, in Texas, it's for all felonies. So what is an indictment? The grand jury formally charges a criminal suspect by issuing an indictment. So another term for an indictment is true bill. You'll hear that fairly often. So if somebody wants to say that another name for indictment would be a true bill. And if the grand jury decides not to indict, we say they no-billed him, no bill. So why do we call a grand jury anyway? Well, this goes back to the fact that many of our terms in the law, we think of the law having a lot of Latin terms, and it certainly does, but it also has a lot of French terms. And that goes back to the fact that, in 1066, William the Conqueror overtook England, and so for hundreds of years, the language of the court was Norman French, and that is what legal matters were handled. And so it's not unusual to see French terms being used in this sense, and that's what we have here. The word jury really isn't a French word, but the word grand is. And of course, we have this word in English, grand piano, I had a grand time, and it can mean in English something very lovely and over the top, or it can mean something just large. And in this context, grand jury means large. Typically, a grand jury has more than 12 people in it, so it's a big jury. And that's what the term comes from, that we're focusing on the fact that there's a lot of people on it. Now, what makes a grand jury is not the number of people, but its function. But that's the background. That's why we have this word grand jury. Now, a trial jury is called a petit jury. And again, you can see in the word petit, you can see the word petite. And in fact, in French, when you have the E on it, it's the feminine version of small. And when you don't have the E on it, you have the male, the masculine version of the word small or petite. And in English, we don't pronounce it the French way, we just pronounce it petit. And that means a small jury. And typically a jury in a criminal case, especially a felony case, is going to have 12 jurors. But there are times where it can have less, especially in civil cases. So when you hear petit, think small, think petite, think trial jury. If you're thinking grand jury, think big, think that probable cause jury. Okay, so this is one path, and this is the path that we have in Texas for felony cases and for federal felony cases. Other cases, though, the non-felony cases, we're going to be looking at a preliminary hearing. This is a court proceeding. A prosecutor presents evidence, and the judge determines that there's probable cause to hold the defendant over for trial. So we bypass the grand jury. Obviously, this process is much less time-consuming, less bureaucratic, saves the county money. And again, if the grand jury is not accomplishing anything in terms of justice, why have extra hoops that aren't really helping anyone? The document that we have for the grand jury is called an indictment. Here we call the document an information. It's kind of weird to put the word "an" in front of information. An information. Usually when we talk about information, we don't put a noun marker in front of it, but that's how you would do it here. So what is an information? The prosecutor formally charges a criminal suspect by filing an information or a criminal complaint. So whichever path you go through, whether it's a grand jury or preliminary hearing path, you're going to end up with a document that charges the person, the criminal defendant, with the matter. This is, we talked before about in the initial appearance, a person has been charged, but oftentimes they haven't actually been indicted. Sometimes they get indicted first and then they're arrested, but sometimes they're arrested first and then we have this grand jury process. So this can come before or in the middle of the process. But whichever path we follow here, we're going to have an arraignment. In this case, the G is silent. And the suspect is brought before the trial court. This is probably not the magistrate at this point. This is going to be the actual court in which likely he will be tried in. So you'll have the same judge who would hear the case. And he's again informed of the formal charges, whether it be the indictment or the information, and he's asked to enter a plea. Let's talk about pleas. What are the choices that the criminal defendant has? Typically, there's two. The criminal defendant can plead guilty or can plead not guilty. There are sometimes a couple of additional charges that the person can plead. Probably the most common is nolo contendere, meaning that he's not contesting his legal responsibility, but he doesn't want to plead guilty. Sometimes courts don't have to allow criminal defendants to plead nolo if the court doesn't want to. There's really no difference between a nolo and a guilty plea. The only kind of face saving is, well, I guess there's face saving is really what it is, that the criminal defendant isn't actually saying he's guilty. And sometimes it can be relevant if there's also going to be a civil case about that dispute. Sometimes that it can give a little bit of wiggle room in the civil matter as well. So, but again, it's usually guilty or not guilty. There's a few other pleas that the person can enter. For example, not guilty, but by reason of insanity can be another plea. But for the most part, those are rare things. We usually have guilty or not guilty. Typically, a person is going to plead not guilty unless he's in the process of accepting a plea bargain. Because pleading not guilty, well, first of all, I'll explain what a plea is. A plea is not testimony. A plea is not a statement. That when the person pleads not guilty, they're not saying, I do solemnly swear that I did not commit this crime. There is nothing unethical or unlawful or perjurous about somebody pleading not guilty, even when he fully knows that he is guilty of the crime. So that's not perjury. There's nothing wrong with that. What he's simply saying when he says not guilty is he's saying, I want to require that the state prove their case beyond a reasonable doubt. And he is entitled to that, so he can definitely plead not guilty. When a criminal defendant pleads guilty, more often than not, it's because he already has a plea bargain with the state. He and the state have already reached an agreement that he will plead guilty and that the state will recommend a relatively low sentence given the circumstances of the crime. The prosecutor has to agree to the plea bargain, the criminal defendant has to agree to the plea bargain, and the court has to agree to the plea bargain. Let's see how that works out. The prosecutor may offer a plea bargain. A plea bargain is a prosecutor's promise to make concessions or promise to seek concessions in return for a suspect's guilty plea. Concessions may include a reduced charge or a lesser sentence. So that is how that works. Now, it's often at the arraignment, the plea bargain is discussed with the court. But if it hasn't been reached, then obviously the criminal defendant just enters a plea. Now, there are times where a criminal defendant will plead guilty even though he doesn't have a plea bargain. There can be strategic reasons for that. If there's really just no dispute about the guilt, there's no argument that this person isn't going to be found guilty, then sometimes a person will still enter a guilty plea even though they want a trial on the sentencing portion of the case. So let's assume, though, that or let's first of all assume that there was a plea bargain entered. So now we're going to go over here to this a guilty plea situation. In most jurisdictions, most cases that reach the arraignment stage do not go to trial but are resolved by a guilty plea, often as a result of a plea bargain. The judge sets the case for sentencing. That is true. Typically, I think I've read somewhere that about 97% of cases are pled out. But if there is no plea bargain, then we're going to go to trial. Now, this chart's a little misleading because what would happen is that after the arraignment, we would go to the trial. We would not have a plea bargain in this middle here. So imagine this error not existing, and we have an error from here to here. So what happens at trial? Well, of course, it's just what you expect. You're going to have a jury trial, and if the verdict is guilty, the judge sets the case for sentencing. If in Texas, which is a little bit unusual, the jury also decides sentencing as well. Everyone who's convicted of a crime has the right to appeal, and they are entitled to representation of counsel for that first round of appeals. Okay, so let's talk a little bit more. We're still in the procedural area. We're still talking completely about procedure at this time. The prosecutor has broad discretion. Unfortunately, there's a lot more crime in any county than the prosecutor could possibly hope to prosecute. So he or she has to make priorities. You know, if he has a choice between prosecuting the shoplifter who stole a piece of gum versus somebody who robbed a bank, well, it's a pretty easy call to make. So the more serious the crime, the more dangerous the crime is, the more likely that crime is going, if it's not prosecuted, will result in additional crimes, are all factors that the and not just the seriousness of the crime, but also the strength of the evidence. You know, if you had one case where, you know, it's a pretty serious crime, but it's kind of doubtful whether we're going to get a successful prosecution because it seems like there's probably reasonable doubt, that might be another reason why the case is not pursued. There's just so many variables that it doesn't really make sense to second guess the prosecutor's decision. As a result, the prosecutor has broad discretion. He or she gets to decide which cases to go forward. If we had a rule that said the prosecutor has to prosecute every single case, we would need, number one, a lot bigger staff of district attorneys and paralegals. We would need a lot more jurors for jury duty. It would have a pretty significant impact upon all of us because higher taxes to pay for all this infrastructure and a lot more time on jury duty. That doesn't probably make a lot of sense. So, you know, is there the possibility that prosecutors could abuse that power? Of course, but there's really not another good way of handling that. We also have, keep that in mind about the prosecutor's authority. We have the complaint and the initial appearance. We talked about that already in the previous statement. The judge and magistrate informs the defendant of the charges and his or her rights. This is during the initial appearance. If the person is indigent and wants an attorney that time, which of course he probably does, then that attorney can be appointed, and of course that bail can be set. This is the initial appearance, and then we have the preliminary hearing. Again, this is in the non-felony cases. We talked already about grand jury review, but let me just see if there's anything here. Nothing really new. We talked about arraignment. Okay, this is something we didn't discuss. During an arraignment, an option that the defendant also has is, well, I guess also the prosecutor could do this, is file a motion to dismiss. Let's say there's some flaw with either the indictment or the information. Well, the defendant could say, Your Honor, there's a flaw with this, maybe a legal flaw, maybe a factual flaw, whatever the problem is, but this isn't good. Dismiss the indictment or whatever, and of course that's something that can happen. Maybe it happens, maybe it doesn't. Between the arraignment and trial, go back to our picture here. So we had arraignment. Again, the plea bargain only happens if we're going to get to a guilty plea. But between the arraignment and trial, we don't have any steps in our picture, but in fact there really are some steps. You're going to have motions and conferences where the prosecutor and the defense attorney and the judge get together. Here are some common motions that we might see. One might be a motion to suppress evidence. This is, in a civil context, would be called a motion in limine. It's also sometimes called that in a criminal context. Remember we talked before about the exclusionary rule where you can, or the defendant can move to have certain evidence excluded, not because it's not probative, not because there's any question about its factual accuracy, but because it was obtained in an inappropriate manner, and we don't want to reward the prosecution when they don't play by the rules. And so this can be a really important motion in pretrial because in certain cases, that may be the most important part of the evidence against the defendant. And so when that evidence is dismissed or not allowed into the court, it may be that there isn't enough evidence to get a beyond a reasonable doubt finding. And the prosecution might, if they lose a motion to suppress, might decide to just dismiss the whole complaint. They still have the opportunity to refile it if they get additional evidence in the future. So there can be some pretty important motions that really affect whether the case goes forward, and if the case does go forward, what evidence is going to be allowed in. Let's talk about discovery. We've taught, or in the textbook, we talk about civil discovery pretty extensively. We talk about interrogatories, depositions, requests for admission, mental and physical examination, and interrogatories, depositions, requests for admission, mental and physical evaluations. But in the criminal system, we don't have those same tools of discovery. In fact, discovery is much, much more limited in the criminal system. For one thing, it's a one-way aspect. The prosecution shares information with the defense, but the defense is not required to share information with the prosecution. In fact, the defendant is entitled to exculpatory and inculpatory evidence that the prosecution has. So what is exculpatory evidence? This is evidence that tends to point to the defendant not being guilty. Inculpatory evidence is evidence that tends to point to the defendant being guilty. If the prosecutor doesn't share this information, especially exculpatory evidence, then that is a very, very serious error. It's going to obviously result in the defendant getting a new trial. But there have been cases of prosecutors who've done that, who have lost their law license and actually have been criminally prosecuted for obstruction of justice. It's a big deal. The defendant, on the other hand, has no obligation to share any of his information with the prosecution. Again, that goes back to the Fifth Amendment, that there's no duty to incriminate oneself, and so they can keep, the defendant can keep all of his information secret if he would like to. As I said before, most cases are going to plea out. Really, that's a necessary part of our system as we currently imagine it. If the district attorneys lost the power to plea bargain, and they suddenly had to try all of their cases, well, they would either have to stop filing very many or pursuing very many charges, or they would have to have a much larger staff. And again, all of us who potentially are jurors would have to serve on a lot more juries. Let's look at the differences between a criminal trial and a civil trial. Well, one big difference is that in a criminal trial, there's a presumption of innocence. In a civil trial, there really isn't a presumption either way. The plaintiff bears the burden of proof, but it's just that preponderance of the evidence standard. In a criminal case, the jury is instructed to presume that the defendant is innocent until he's proven guilty beyond a reasonable doubt. And so the jury is really supposed to continue presuming innocence for quite a while. Now, this presumption isn't necessarily a logical presumption. It may be that it's obvious immediately that the criminal defendant is factually guilty. Maybe the first thing that the jury sees is a videotape of the criminal defendant committing the crime. It's kind of silly to think, well, this person is innocent at that time, since the evidence seems clear that he's not innocent. So this presumption isn't quote unquote logical. Obviously, the vast majority of people charged with crimes are probably going to be guilty. We would have a pretty poor justice system if we routinely indicted innocent people. It certainly happens. It's tragic when it does, but it's not a routine thing. And if it were a routine thing, boy, then we would need to change our district attorney, because that wouldn't be right. So a juror would be right to think factually, this person is highly likely to be guilty. There's probably at least a 95% chance, certainly a 90% chance that he is factually guilty of the crime. But at the same point, even though he intellectually knows that information, it's the obligation of the juror to put that fact aside, to not consider that fact, and instead to presume that he is innocent until the point that he is proven beyond a reasonable doubt to be guilty. Unlike the civil situation where a person can be compelled to testify, a criminal defendant has the right, has a privilege not to self-incriminate. He does not have to testify. And if he chooses not to testify, the prosecution can't comment upon his decision not to testify. Now, if a criminal defendant chooses to get on the witness stand and testify, then he will have to answer all questions. He can't assert the right against self-incrimination in one moment and then not the next. And we already talked about the right to a speedy trial, which doesn't exist in the civil system. A unanimous verdict is required. Again, that's not typically required in the civil system. It can be for conviction or acquittal. If there isn't a unanimous verdict either way, then there's going to be a hung jury. So it can hang with, a 1-11 or an 11-1 verdict. If a jury is hung, then the case can be retried. Of course, if the defendant is found guilty, then they move to the sentencing phase. And the statute's going to set forward what are the possible sentences. And when we were looking, for example, in the previous lecture about homicide, we saw that there are different categories. Of course, there's the petty offenses, there's the misdemeanors, and there's felonies, but there's degrees within those categories of punishment. So you can see things like incarceration, probation, fines, public service, things like that. In Texas, typically the jury is going to decide sentencing, although the defendant can choose to have it be the judge. Let's talk about criminal diversion. There is a question on the final examination about this, so you're going to want to flag this. For one thing, this is a Texas issue, so you're not, well, the concept is probably in all 50 states, but the terminology here relates to Texas law, so you won't necessarily find this exactly in the textbook. So we have this idea of criminal diversion. What is that? Well, the first thing to keep in mind is that the term that we use in Texas for this is deferred adjudication. This is something that is done instead of prosecuting. This is typically done for first-time offenders who have committed a nonviolent crime. Oftentimes it's a DWI or a relatively minor drug offense. And if the individual were to be prosecuted, there would be a lot of negative implications for that person's life. Perhaps they're going to find it very hard maybe to find employment. And so if they can't find lawful employment, that might cause them to engage in more serious criminal conduct to feed themselves and take care of their families. And so it might just kind of be the beginning point of going into more serious misconduct. The hope is that by catching these folks at the early stages of their criminal behavior, maybe we can still turn them around. And so this is the equation for that. And again, it's what we have in Texas, the deferred adjudication. So what happens is, let's say I have a relatively small drug offense, my first offense, there's no violence involved, and I will reach a plea bargain with the district attorney. I agree to plead guilty. I agree to, say, probation, and other requirements. Maybe I'm going to be subject to random drug screens and alcohol screens. I have to either be attending college classes or perhaps be employed. Maybe I have to stay away from certain people who might have been involved in my criminal lifestyle. Anyway, and at some point in time, my probation will end. Well, during that period of time, let's assume that I play by the rules. I don't violate any of the terms of my probation, and at the end, I get a good report from the probation officer. Well, then I have my adjudication, my conviction, my plea bargain, it gets erased from the record. It's like I never committed a crime. And I can honestly say when I apply for a job, I have not been convicted of a crime and can go about my business as if I didn't have any of this run-in. But so that's the happy ending story. The less happy ending story is in the middle of my probation, I stumble a little bit. Maybe I fail a drug screen, or I don't maintain my employment, or I violate some other term. I don't maintain regular conduct with my probationary officer. And so I am reported to a judge, and the judge decides to revoke my probation. And at that moment, then I become convicted. It's no longer deferred. It's a final adjudication at that time. My guilty plea back at the beginning now becomes my real plea, and I'm likely to be incarcerated at that point. And when I'm done with my incarceration, I do have a conviction. And so when I apply for jobs and they do a background check, they will find that in fact I am a convicted felon or whatever the situation might be. So again, it's a second chance, but it's a second chance that can be blown. And of course, this is a plea bargain aspect. But let's say that I choose not to engage in a plea bargain. I go to trial, I'm convicted, and I want to appeal that. As I said before, criminal defendants have an automatic right of appeal, and if I was eligible for appointment of counsel for my trial, I would be eligible for appointment of counsel for my appeal. As a result, since the vast majority of criminal defendants who actually go to trial are represented by attorneys at the cost of the county, and so it's free for them to file an appeal. As you can imagine, most of them are going to say, well, yeah, sure, why not file an appeal, even if there isn't the best basis for the appeal from a legal standpoint. Obviously, you can't file an appeal if you've entered into a plea bargain. And if the prosecutor loses, let's say that the defendant was acquitted. If the prosecutor loses, he or she has very limited bases for appeals. It can appeal certain things. For example, let's say the judge had excluded certain evidence because of the exclusionary rule. Typically, the prosecutor can appeal that. But if the jury just happened to have returned a not guilty verdict, and yet there wasn't some evidence that was excluded that was significant, in most cases, the prosecutor's just stuck with it. The person's going to acquit it. He can go about his business. So here's a summary. I won't reiterate the things we've already discussed, except just to flag them for you. We have some differences between civil and criminal liability. We have two requirements for criminal liability typically. We have the actus reus and the mens rea. Actus reus. And we have the mens rea. Mens in this context is referring to the mind, as in mental, not referring to males. Obviously, this is a Latin term. This isn't an English language term. Then we had the 5 traditional categories for crimes. This is one way of dividing up crimes. Again, there's overlap. Organized crime can be violent or property. White collar is typically going to be property crime. We talked about the protections in the Bill of Rights. For this course, you do not need to know the numbers of the amendments, but you do need to know the protections that are afforded. We talked about the procedure, the arrest, booking, the initial appearance, the arraignment, the grand jury or preliminary hearing process, the plea bargain possibility, the trial, the appeal. We talked about the differences between criminal trials and civil trials, the presumption of innocence, the burden of proof, the privilege against self-incrimination, the right to a speedy and public trial, the need for a unanimous verdict, and how sentencing is handled. By the way, in a civil case, typically the jury just returns a verdict at one time. Who won and how much, if the plaintiff won, how much the plaintiff is going to be paid. There's a bifurcation in the criminal context. You have the guilt or innocence phase, and then you have a second phase. If assuming the person's found guilty, you have a second phase where additional evidence is presented. Both parties get to present evidence relating to the appropriate punishment that might occur. You may think, well, why do we have 2 phases? Well, what's the benefit to that? Well, the reason for that is that if you were to allow in the sentencing information before the jury has found the person guilty or not guilty, the information that's allowed in at that time might prejudice the jury because they're going to find out maybe information about prior criminal conduct of the defendant, and that might make them think, oh, well, this person's already done something kind of similar. They probably did this as well. So it would prejudice the jury against the defendant, and so we keep that information separate until after guilt has been established. If you have any questions, please bring them to class. I look forward to hearing them if you have them. Thanks for your attention, and have a wonderful day. Bye-bye.